Good afternoon. Good afternoon in Austria and as well in Malta. So my name is Aurélien Lorange. With my colleagues, Mr. Bonova and Mr. Sanchez, we will be hosting a match from the group phase. This is the first match for these two teams who are in the group E with two other universities. They will be debating on a topic they received a week ago. So this is the first day of the competition for them. And of course, before we get to the match itself, it is time to get to know about them particularly. So I would like to give the floor first to Miss Lily Stadler Vida. Welcome.
Hello. What? I'm really happy to be here. Can 1 second?
Oh, wait.
Yeah.
Yeah.
Okay. I'm really happy to be here, and I'm really excited for this debate. I'm a student of University of Vienna. I'm studying international law, and I'm a member of the Juridicum Debating Society, which is our debate club.
Thank you. Welcome. We have in Malta Miss Karaborg Aquilina. Welcome.
Thank you very much. Good afternoon, everyone. My name is Cara, representing the University of Malta. I'm in my third year of my Bachelor's of Law, and I'm really grateful for this opportunity and looking forward for a fruitful debate.
Thank you. Welcome. We have as well in Vienna Mr. Felix Graffinger. Welcome.
Hello to all. My name is Felix, and I'm studying as well the Bachelor for International Law, and very happy to be here. Also one of the founding members of the Debating Society, and glad that we can represent the university and also Austria today. Thank you.
Thank you. Welcome. And we have as well in Malta Mr. Michael Gatt. Welcome.
Thank you. Looking forward to joining this debate as well. I'm Michael. I'm 22 years old. I'm at the University of Malta as well, studying Bachelor's of Laws in my fourth year now as well. So looking forward as well to participating in a fruitful debate.
Thank you. Welcome to this match. And a third member for the team of the University of Vienna, Mr. Leonard Laffer. Welcome.
Thank you very much. Yes, my name is Leonhard, and I'm in my second year of the Austro International Law Bachelor here at the University of Vienna. I'm really looking forward for this debate, and I wish everybody good luck.
Thank you. Welcome. Before we start to the allocation of position, I send greetings to your coach as well. So on the side of the University of Malta, Dr. Antoine Grima, Professor Omar Gresh, and Professor Tonio Borg. And greetings to the Dean as well, Ivan Mifsud. And on the side of the University of Vienna, Magister Martin Strebel. So now my colleague will be sharing her screen with a wheel. So the wheel where you will see the positions available for this match in favor and against. And each university has these two positions. The team in favor will be starting with the first introduction. So for this match, the University of Vienna will take the position against the motion, and as a consequence, the University of Malta will be in favor of the motion. So it means concretely the University of Malta will be starting with the first introduction, and we defend that competition law must be applied in a manner that reflects transnational market structures, while the University of Vienna will defend the position that competition law must not be applied in a manner that reflects transnational market structures. So now you will have 5 minutes to review your notes, and then we'll hear the introduction by the University of Malta.
Thank you, everyone. Your time for final preparation has now passed. We'll be starting by hearing the opening statements for the in favor position by University of Malta. You have 4 minutes.
Thank you very much. Am I audible and visible?
Yes, you are.
I will start in 3, 2, 1. Honourable judges, esteemed opponents, good afternoon. The motion asks whether competition law must be applied in a manner that reflects transnational market structures. We submit the affirmative, not as a dogmatic proposition, but as a matter of doctrinal coherence, enforcement effectiveness, and economic reality. Competition law exists to protect rivalry, safeguard consumer welfare, and ensure market contestability. Said objectives become hollow if enforcement tools remain confined to national borders, while the markets they purport to regulate are functionally global. Between 1990 and 2016, detected private international cartels affected sales exceeding $51 trillion worldwide, with estimated global overcharges surpassing $1.5 trillion. This is not hypothetical harm, but wealth extracted across borders through coordinated conduct structured precisely to exploit the jurisdictional seams of purely territorial enforcement. If competition law refuses to look beyond the border, it is not neutral but becomes structurally complicit in that extraction. Our case rests on 3 contentions. First, market analysis must match transnational market reality. Competition law only fulfills its purpose when enforcement tools map onto how market power is actually built and exercised. Today, that means cross-border corporate groups, integrated supply chains, and platform ecosystems whose effects spill across jurisdictions. The use concept of an undertaking already operationalizes this. So does the effects doctrine, validated in cases like Woodpulp and Intel, which grounds jurisdiction not in the place of formation of conduct, but in where anti-competitive effects are implemented or materially felt. Second, enforcement must be networked to police transnational structures. Regulation 1/2003 and the European Competition Network already institutionalized this premise within the EU. Parallel competence, information sharing, and coordinated enforcement, for example. The ECN Plus directive goes further, harmonizing enforcement capacity precisely because transnational markets are only as protected as the weakest authority with jurisdiction over a key node. Internationally, the OECD, UNCTAD, and the ICN have built cooperation frameworks, procedural convergence mechanisms, and capacity-building programs that treat cross-border enforcement not as discretionary, but as structurally necessary. Over 130 jurisdictions now maintain competition law frameworks, and the OECD's Global Forum convenes more than 110 competition authorities annually. Third, remedies must be designed transnationally or they are porous. Even where jurisdiction and liability are established, a remedy that binds only domestic contracts can be circumvented by routing supply through foreign affiliates. Divestiture obligations mean nothing if the competitive constraint operates through global platform rules or cross-border parity clauses. The OECD's work on extraterritorial remedies acknowledges this directly. Remedy design must follow the economic mechanism of harm, not the formal geography of the subsidiary. Crucially, we do not advocate unconstrained extraterritoriality. Our position incorporates established limiting principles, effects thresholds requiring foreseeable, immediate, and substantial impact, implementation-based jurisdictional ties, committee-aware remedy coordination, and economic unit analysis targeting real control. Both the EU's Qualified Effects Test and the US Foreign Trade Antitrust Improvements Act converge on this disciplined, effects-based framework. The motion does not ask us to invent a new legal order. It asks us to be honest about the current realities we face and recognizes the need to regulate said realities in a functional manner. I thank you.
Thank you. We'll now hear the opening statement by University of Vienna for the against position. You have 4 minutes.
Am I audible and visible?
You are.
I will start in 3, 2, 1. Honorable judges, esteemed opposition. In my speech, I will bring 2 arguments to demonstrate why competition law must not be applied in a manner that reflects transnational market structures. As competition law, we understand all kinds of competition law, including, for example, unfair competition law and public procurement law, as none of those competition laws have to be applied in reflection of transnational market structures. Under application, we understand any use of competition law in this reflection, be it in court judgments, but also in others. Finally, as reflect, we understand the mirroring of the structures of the transnational market in any application by reference and consideration in decisions of authorities, court judgments, and so on. Coming to the points, for the first point, we want to emphasize that the word must in this sentence is too strong. It implies a single, unavoidable course of action and leaves no room for alternative, proportionate responses. Cross-border problems can be addressed in other ways, such as mutual recognition agreements that require each state to enforce competition rules within its own territory. For example, the famous Intel case, which was brought up with the cross-border application of competition law, could have been prevented if China would have enforced the competition law itself. Therefore, the application of competition law in a manner that reflects transnational market structures, even if useful, is clearly not necessary, as the ratio of competition law itself, protecting the consumer and the competitors, can be achieved through other means, as I have shown. Secondly, applying competition law in a transnational manner risks undermining state sovereignty. Differences in legal systems, policy priorities, and market structures mean what looks like an anti-competitive practice in one jurisdiction may be lawful or even necessary in another. For instance, a behavior that appears to be a cartel under one country's rules may be seen as legitimate market coordination in the country where it is based. For example, in the animal science products v. Hebei case, where Chinese sellers of vitamin C were found to have been compelled by their own government to form a cartel, the Supreme Court of the United States of America held that US law could not reach conduct that was lawful and required under another country's legal regime. This approach is justified, as one state should not apply its competition law to conduct that occurred entirely within another state, in this case China. Otherwise, countries could lose judicial autonomy, state sovereignty would weaken, and enforcement could become unequal as regulatory power concentrates in the hands of economic heavyweights. Also, this encroachment on state sovereignty will increase the pressure on states to present themselves as attractive legal orders even more, triggering a hyperliberalization that risks a race to the bottom and could ultimately undermine the enforcement of competition law altogether. Consequently, the motion's use of the word must overstates this case by far. There are viable, less intrusive alternatives to transnational application of competition law. Extraterritorial enforcement risks undermining sovereignty and produces unequal outcomes. National enforcement combined with cooperation can protect markets without imposing one jurisdiction's rules on another. For these reasons, respectfully urge you to reject the motion as written. Thank you.
Thank you for your opening statements. We'll now proceed to the first rebuttal for the in favor position. University of Malta, you have 2 minutes.
Thank you. Am I audible and visible?
You are. Let's check one more time for the echo.
Sorry, am I audible and visible?
Yes, perfectly. Thank you.
I'll take it as yes because I see some nods. So I will start in 3, 2, 1 to address some of the issues posed by the other opposition. Their focus is that the statement is focusing on must, and they're saying that it is too harsh. We respectfully disagree. We must keep in mind that international law is always a gradual process. This is not something that we're hoping will happen tomorrow. This is something that we're hoping will happen over time. We must, yes, this is the whole point of this statement, that eventually we are moving towards this direction. It is very important to keep in mind that we are modernizing the current situation. We are moving with the times. We cannot stay with the archaic system that is currently in use. It is not effective. It has not been effective, and it will definitely not be effective in 20 years' time. Why? Let's focus on a specific case. There is a case in Indonesia on the Temasek case in which a Singapore-based sovereign wealth fund made use of this as well. Indonesia, they applied their competition law on foreign shareholders as modern markets use transnational ownership. This shows that competition law must adapt accordingly. They cannot adapt to the current system. It must continue to evolve into the system as well. So as another point, the opposition also focused a lot on national sovereignty. The opposition is framing transnational application as an assault on sovereignty, but this mischaracterizes the motion. We are not proposing a single global antitrust authority or the subordination of national law to an international regime. We are proposing that national authorities apply their own law in a manner that acknowledges economic reality. Furthermore, there are committee principles, the IFCN framework on committee procedures, agency procedures, and OECD procedures, as my colleague has already mentioned, that already act as safeguards as cross-border enforcement. As maybe a final point as well, because we focused a bit on cartels as well, I would like to focus on another case, the Samsung LG case. This was a case that was held in Brazil and concerned a global case in CRTs which used TVs and computers. Again, this showed how eventually the global firms must be regulated globally to prevent abuse and discrimination. Thank you.
Thank you. We'll now hear the first rebuttal for the against position, University of Vienna, 2 minutes.
So can you hear me?
Yes.
Yes, perfect. So, respected judges, dear proposition. So first, I want to talk about the number you mentioned in your introduction speech. You claimed $3 trillion were overcharged because of national enforcement, but it's important to mention that this figure is obviously speculative. Cartels are secret by nature. The causation is not clear. You cannot simply say, yeah, because there was a failure to mirror transnational markets, this number happened like that. And also I want to talk about enforcement. So every state is responsible for their own citizens. Obviously, no legal system offers perfect global enforcement, but the existence of jurisdictional boundaries reflect institutional design, not dysfunction. And competition authorities already coordinate internationally. Isolated enforcement challenges do not require structural redesign of antitrust law. Now I want to move on to what my dear colleague has shown before, the flaw in the proposition's case with the meaning with the single word must. By insisting that competition law must be applied to reflect transnational market structures, they demand a one-size-fits-all approach that ignores a fundamental political reality. The globalization trilemma. States cannot pursue deep global integration, national sovereignty, and democratic legitimacy at the same time. One of these always must give way. And the thing is, there are better alternatives. That's what the proposition likes to ignore, because the frameworks such as ACEAN's mutual recognition model and the APEC privacy framework exist, and they show that working together does not require imposition. States agree on common standards, but retain the freedom to implement them with their own legal tradition and cultural context. Also, because we talked about enforcement before, law enforcement looks so different in every single state, it would be dumb to ignore that. We do not reject cooperation. We reject harmonization.
Thank you. Now to hear the second rebuttal for the in favor position, University of Malta, you have 2 minutes.
Am I visible and audible?
You are.
Thank you. I will be starting in 3, 2, 1. I would like to thank the opposition for their remarks, but I will have to focus more on the element of must. So, as the proposition, we believe that must should be read as an obligation of cooperation and alignment, not as instant full harmonization. So the motion doesn't require a world antitrust code to be developed tomorrow, but it requires recognizing that transnational market structures already exist. And so effective competition enforcement can't remain purely siloed as the opposition is proposing, even with their possible reforms that they're suggesting, because cross-border cartels and dominant strategies, they distort market access and the conditions of international trade as a whole. And so, therefore, must expresses a necessary normative commitment. States and institutions, they must coordinate enforcement standards and information sharing to make the trade rules functional in practice, as my colleague mentioned with regards to a gradualist approach. Also mentioning the point that was raised by the opposition on sovereignty, I just wanted to clarify that the effects doctrine that we had mentioned, the very mechanism for transnational application, is in itself an expression of sovereignty. So when a state asserts jurisdiction over foreign conduct that causes domestic harm, it's protecting its own market and its own consumers. So the EU's qualified effects test and the US FTIAI, which I mentioned in my opening statement, both require that effects are foreseeable, immediate, and substantial. And the real threat to sovereignty is the opposition's own model, therefore. And also, to close on the element of extraterritoriality, conflicting obligations for multinational firms do not arise from transnational application, they arise from its absence. So when authorities define markets differently, apply divergent thresholds, and reach contradictory conclusions on the same merger or conduct, it is precisely because they are operating in isolation from one another, ignoring the transnational structure they all regulate. Thank you.
Thank you. Now for the second rebuttal for Dagin's position, University of Vienna, you have 2 minutes.
So, what is important to understand in this debate is that there is a reason that competition law is rooted in territorial jurisdiction. Because markets, we are not disagreeing on that, are globally connected. But the thing is that legal authority is not. We are not saying that they shouldn't cooperate or that it's not important that every state communicates with each other. But in practice, if we have enforcements, larger jurisdictions with greater market power inevitably set the standards, while smaller states are pressured to adapt in order to maintain market access. So when we attempt to apply competition law transnationally, we do not simply improve coordination, we shift political power. So there are ways, as I mentioned before, to have coordination without shifting that power. We limit the ability of nations to make their own economic choices, and that creates a regulatory friction. We are already seeing this tension. The extraterritorial reach of the European Union has triggered what many describe as Brussels fatigue. Instead of creating harmony, this has led to countermeasures from other major powers. For instance, look at the wave of data localization in China, Russia, and India. These states are not exploiting loopholes. They are asserting digital sovereignty against foreign states foreign standards that conflict with their own security and cultural norms. To preserve legitimacy, competition enforcement must remain grounded in territorial authority and not be transferred to a distant technocratic framework that overlooks national diversity. Because what the proposition is ignoring, that someone for this international framework, someone has to make the decisions, and we do not see a way that every state is going to be able to bring their own opinions into that.
Thank you. Now we are moving to hear the closing statements, starting with University of Malta. You have 2 minutes.
Thank you. Am I audible and visible?
You are.
Yes. So I will start in 3, 2, 1. Honorable judges and distinguished audience. Global firms must be regulated globally to prevent harm. Competition law was not designed to protect borders, but to protect markets. The question this motion poses is whether those objectives can be achieved when enforcement remains willfully blind to how markets are structured. We have argued they cannot. Transnational corporations operate as an integrated economic units across jurisdictions. International cartels coordinate conduct offshores while extracting billions from domestic consumers. Digital platforms exercise gatekeeping power through cross-border ecosystems that no single national authority can adequately assess online. In each instance, a purely territorial approach produces systematic under-deterrence. The evidence overwhelmingly indicates that to ensure fair competition, a smooth transition into the future market, the transnational model must be adopted. The leap is clearly legally justified and practically sound, as shown by the case law shown before. There have been cases adopted, jurisdiction adopted through countries that are developing countries, current across the globe, essentially. So there is basis to it as well. We have also shown that this approach carries built-in discipline. Effects, thresholds, and committee principles ensure that transnational enforcement remains legitimate and respectful of sovereignty. The convergence of EU's qualified effects tests and the US FTAIA on this point reflects a shared recognition that enforcement must follow harm, not formal geography. The opposition may frame transnational approach as overreach. We submit that this is the opposite. A competition law that refuses to see beyond the border does not protect sovereignty. It abandons consumers to the very market failures the law was created to prevent. Competition law must reflect the market it governs. That is not an aspiration. It is a condition of its legitimacy. Thank you.
Thank you. For concluding statements of University of Vienna, you have 2 minutes.
Thank you. Am I audible and visible?
You are.
Thank you. I will start in 3, 2, 1. Honorable judges, esteemed proposition. To conclude for the opposition, the motion fails because it turns a complex governance choice into an absolute command. It is not true that competition law must be applied so as to mirror transnational market structures. That single word imposes a rigid model when reality demands calibrated and context-sensitive enforcement. First, the proposition confuses cross-border problems with a cross-border mandate. Yes, firms trade internationally, but it does not follow that domestic competition law must be stretched to track every global market map. This leads to issues where domestic problems are attempted to be governed by transnationally cut competition law and enforcement. Second, the motion ignores the core constraint of sovereignty and democratic legitimacy. Competition law is not merely technical economics. It expresses public choices about market structure, industrial policy, and acceptable coordination. Those choices differ for good reason. When one state's judgment becomes decisive for conduct and firms operating in another, you do not get a neutral reflection of markets. You get regulatory dominance. The conflicts in cases like animal sciences products show where conduct is compelled or authorized under a foreign regime, it produces direct friction and undermines the premise that states govern their own economic life. The proposition's approach risks concentrating regulatory power in economic heavyweights and exporting standards to weaker states regardless of local conditions. Third, even on the proposition's own terms, the model risks worsening enforcement. Once competition law becomes the shadow of global corporate structure, you invite procedural complexity, conflicting standards, and retaliatory measures, which scholars describe as regulatory friction. This is not hypothetical. Overreach can provoke countermeasures such as localization requirements and defensive regulation, further fragmenting markets and creating sustained legal uncertainty, which chills investment and innovation. Our position is not anti-cooperation. We accept and support coordination. What we reject is coercive harmonization dressed up as necessity. Thank you.
Thank you. Thank you to both teams for your concluding statements and arguments. You can all now relax. You're no longer graded after this part. On behalf of our organizing team, really well done on completing your first debate match of the 2026 edition. Well done for your research and for your execution during the debate into the arguments. Of course, the 3 judges that are reviewing your match, perhaps already watching now through the live stream or later through the recordings, will have 2 business days to review and submit their scorecards. When our team receives them and validates them, we'll share them with you. But already now you can do a short feedback session with each other on how you found the topic. If you heard perhaps some familiar arguments that you prepared during your research for the other side of the arguments, and just in general for the debate. Starting with University of Vienna, Ms. Stadler-Wieder.
Yeah, I thought it was. Warte, kannst du wieder?
Sorry.
Yeah. I thought it was really interesting. It was really interesting to hear the arguments I have prepared myself. I thought it was pretty challenging to rebuttal the things in the moment, especially from that side. But I really liked hearing it, and I also thought it was interesting because some arguments the other team brought I haven't prepared before, so that was nice. So it was really interesting. It's really fun.
Thank you. Ms. Aquilina, the same question for you.
Definitely. First of all, I'd like to thank the University of Vienna students for engaging in such an interesting debate. It was very insightful for us, and it was interesting as well to see how arguments that we've also prepared were expressed in different terms or from different angles and perspectives. So that was also very interesting. And I just want to thank all of you, and it was very engaging, and hope for the next one.
Thank you. Mr. Graffinger, for your team.
Well, I could only say the same. I don't want to repeat what the others have already said, but also thank you for this engaging debate. And I must say, you really gave us a challenge there, and I'm very glad that you did. It was very interesting to hear you speak, and in general, it was a pleasure to compete against you already. I wish you all the luck for your other rounds. And yeah.
Thank you. Mr. Gout, passing the floor to you.
Thank you. I'm going to reiterate a lot of what has been said as well. So thank you, of course, to the opponents. You put up a really good debate, and it was a pleasure to have the first debate with you. I thought the points were very interesting as well. We obviously, when we tried out the other side as well, we came up with a lot of similar arrangements. Even the cases were very similar as well. So it was nice to see the other perspective debated so well as well. So congrats to you, and best of luck for the rest of your tournament as well.
Mr. Laffer.
Yeah, of course. I also can agree what the other people said. And
Sorry.
I'm sorry. And yeah, and I think it was also a really interesting debate. I think the topic was really, really well chosen because it just shows how many issues there are in international law. And of course, I think it was really interesting competing against the University of Malta. And I, of course, wish you guys all the best for the rest of the competition.
Really well done to the two teams. It's been a pleasure to be able to observe your first match of the competition. I'm really looking forward to your next ones. As you know, the next match will happen for you in about 2 weeks. So a week in advance, you're going to receive a new topic. So all the best for that progression. Before we wrap up today's session, passing the floor to Professor Lohange for a little bit of networking today.
Yes, well done for this first match. That was really, really nice to see your start and as well representing your own country. And in 2 weeks, there will be another session with different universities against you. So now we would like to know more about yourself as well as the start of the competition. We always have a bit of questions at the end of each match. So for this match, we ask you about your motivation and as well what you would advise to see if the opposing team would come to visit you for the first time as well. So I would like to give the questions first to the University of Malta. So yes, I mean, it could be Mr. Borg or Mr. Gatt to answer each of the questions, for example. What motivated you to represent your university, and as well, what does it mean to be in that competition for you? And the second question, don't forget, imagine that the University of Vienna is coming to Malta, maybe for the first time, what they should see, visit, experience.
Thank you. So my personal motivation is I've been debating for these last 8 years at least. I've been participating in local debates, foreign. It's always amazing to see this intercultural aspect, how it, and especially this time, to see it from a legal perspective is a bit different for me. I'm more used to maybe international relations, EU as well. So seeing this different perspective is quite interesting for me as well. I think if I had to welcome the University of Vienna, I would say, come see our cultural sites. We are very rich with history in Malta. We are blessed to have some of the oldest temples in the world as well. So I think that is the first place I would advertise for you to come see, because they are truly a wonder to see.
Thank you. Ms. Borg, you want to add?
So I'd like to tell the students from the University of Vienna, welcome. Please come visit Malta. As Michael said, we have the oldest freestanding temples in the world. So that is, and we have a mixture, combination of culture. We have very good weather most of the year. So that's also a very big plus. And definitely we also have great artwork, and St. John's Co-Cathedral in our capital city is also magnificent. So culturally very rich, even though we're a very small country. And what motivated me to take part in this debate tournament is, like Michael, I do enjoy debating on other topics. I haven't had the opportunity to do debates specifically on legal topics, but through my exposure to international affairs and relations in other endeavors that I've been involved in, I also wanted to bring those skills and refine them more through this opportunity. So once again, thank you. And yeah, thank you.
Thank you very much. Now the same questions to the team from Vienna. Your own motivation and as well what to experience first time the Maltese students would come to Vienna.
Yeah, thank you very much. Concerning my motivation, I have been debating now for 1.5 years, and I think debating is really important because it helps you just to get into dialogue, and this is how like academics work and how the political, like democracies it works, and therefore I think it's just important to argue, to debate, and to find the best solution for the problems. And concerning the second question, I think when the guys from the University of Malta will come to Vienna, I guess probably Vienna also has a lot of culture, in general Austria, I would say, from the Habsburg monarchy. And because it was said that, like in Malta, it is quite warm. Here in Austria, actually now today it snowed. So if you guys already want to see some snow, maybe a bit, you can also come to Vienna.
Thank you. Your colleagues want to add something?
Well, first of all, I also wanted to thank the organizers, so Mr. Lorange and also Ms. Urbanova. I hope I didn't slander your names. Excuse me if I did. Well, yes, thank you for chairing this round so wonderfully. And what I would say you should definitely check out when you come to Vienna is not only the museums, but also we have some great churches that you can come and visit. As for food, I would definitely recommend you try a Wiener Schnitzel. It's one of my favorite foods, and my mother always makes them every Sunday, so it has to be good if I've been eating them for all of my life. Yeah, you should definitely try it out, and I hope you come visit sometime.
Thank you. You want to add something, Ms. Stadler?
I don't really have anything to add to that, but we would be excited to host you here. And our university building where the law faculty is not the prettiest, but we have a beautiful one right across the street, so it's worth checking out.
Okay, perfect. So thank you very much. Thank you for your first match in the competition. You are the pioneers, actually, for your university. And of course, we thank as well the judge. In 2 working days, we expect their grading their score sheets concretely for your match. We share with you by email the results first and then announce the result. And yes, in 2 weeks, day 2 match for your teams against Paris, Sorbonne, and against United Arab Emirates universities in your group. And so yes, do not hesitate to watch as well the match of your opponents, so that can help as well. So many thanks, and keep contact as well between students, as well between universities, so that might be useful for your career, and maybe if you become friends, even to really visit the countries. So many thanks again, and we keep in touch, and see you soon, and have a good weekend. Thank you.
Well done, everyone.
Bye-bye. Well done.
Thank you.
Thank you very much.
Thank you.